morning, everybody. Lori Vallow has made her first appearance in an Idaho courtroom to face charges related to her two missing children. Vallow's family claims she joined a cult with her husband, who has written books about the end of the world. J.J. Vallow, age 7, and Tylee Ryan, age 17, have not been seen since a family trip to Yellowstone Park nearly 6 months ago. Vallow faces the charges on your screen. The first two are felony counts of desertion and non-support of dependent children under the age of 18. Then there are 3 misdemeanors. The top felony counts carry possible prison sentences of up to 14 years and a fine of up to $500. The judge read the charges and asked if Lori Vallow understood them.
Do you understand the charge in count 3 as well as the maximum penalties?
Yes, I understand the charge.
Do you understand the charge of count 4 as well as the maximum penalty?
Yes.
Ms. Daybell, do you understand what's been alleged in count 5 as well as the maximum penalty?
I understand.
Ms. Daybell, do you understand that all of those charges and their maximum penalties could run consecutively, one after the other, or they could run concurrently, meaning at the same time? Do you understand that?
Yes.
Vallow's defense then asked to reduce her bail to $50,000. A judge in Hawaii set it at $5 million, a figure the defense said was astronomical.
Lori is presumed innocent as she stands before the court today. The fact that she is presumed innocent is not a loose guideline. It's a foundational principle of the American criminal justice system. Under both the 8th Amendment to the United States Constitution and Article 1, Section 6 of the Idaho Constitution, excessive bail is prohibited. This is not a court of public opinion. This is a court of law. And are we going to let our citizens' rights be dictated by what appears in the media? A $5 million bond is unreasonable, it's astronomically excessive, and is the functional equivalent of holding Lori without bond. This is a violation of Lori's constitutional rights. I can tell the court that in my almost decade of practicing law as both a prosecutor and a defense attorney, I have never seen the crime of desertion charged. This is because abandonment issues are generally dealt with under the Child Protection Act, not the criminal code.
And the court set Vallow's bail at $1 million. The state of Florida is attempting to prevent the Parkland school shooter from arguing that he is guilty. The state filed a motion in limine, that's a pretrial evidence ruling, which would, if granted, prohibit the defense from saying Nikolas Cruz is guilty during opening statements unless Cruz gives his express approval. Some observers are saying that move may simply be a state attempt to prevent an appeal issue, but either way, it does reignite the debate over whether the state should accept a guilty plea or try Nikolas Cruz purely in an attempt to put him to death. Let's jump in with our panel right now. Attorneys David Ring, Mike Korabanix, and Michael Bryant are all here tonight. So Michael Bryant, this almost reminds me of the defense tactic when Cruz was arrested. His public defender said he'll plead guilty right now if the state would take the death penalty off the table.
Yeah, well, that'd be a great deal, too, because there's no way he's going to avoid it. And the public really wants to know the story. The victims' family members, they deserve more than some sort of backdoor deal, some backroom arrangement. No, that's just not going to fly.
David Ring, your take on this. It seems that some people, and assuming some victims' families, want the death penalty on the table here. So should the defendant be allowed to avoid it?
The defendant doesn't get to dictate what the punishment is. And so this is a death penalty case, and I think it's going to go to trial as a death penalty case.
Mike Korabanix, but speaking from the defense side, look, the defendant has the constitutional right to put the state to its burden and to be tried, but the defendant also has the right under the criminal code in Florida to plead guilty.
I think it's a good move by the defense. I don't think a judge will deny them the ability to do that. And the prosecution better watch, because if she does, I think they're going to have a serious Sixth Amendment question on appeal.
Many questions remain in that case. Very curious to see exactly how the judge is going to rule and how the defense is going to respond. R&B singer R. Kelly has pleaded not guilty to new federal child pornography charges in Chicago. The 53-year-old artist will be facing even more charges involving yet another victim. Prosecutors told the judge that new charges would indeed be coming as agents seized more than 100 electronic devices related to the Kelly prosecution. Defense attorney Steve Greenberg, however, said the items came from a facility where Kelly keeps equipment, and Greenberg says he does not expect prosecutors will find anything incriminating. We've learned a little more tonight about what happened to Harvey Weinstein in New York's Bellevue Hospital. Surgeons placed a stent in Weinstein's heart, reports indicate. Weinstein is due to be sentenced next Wednesday, March 11th, on 2 sex crimes convictions. Law&Crime host and New York public defender Brian Buckmeyer, however, wonders if Weinstein's sentencing might move forward on schedule or whether it might be pushed back, since Weinstein's hospital stay may have interfered with a pre-sentence investigation. Weinstein is currently at New York's Rikers Island jail. No live court today in the Robert Durst murder trial, but we do need to run through some of the late opening statements from yesterday. Durst is accused of killing his friend Susan Berman in December 2000 because prosecutors think Durst feared she was going to run to the police with information that he had killed his wife Kathleen in 1982. Kathy Durst is presumed dead, but her body has never been found. Prosecutors are also tying in the death of 71-year-old Morris Black. Durst was tried for murdering Black, but he said a struggle for a handgun ended in a shot to the head in self-defense. The jury acquitted Durst of that murder. Durst later pleaded guilty to dismembering Black's corpse. The prosecutor told the jury that Durst monitored news reports about Susan Berman's death and then took off back home to New York when the story went national, even then got married.
On December 6, 2000, concerned that he was about to be arrested, Mr. Durst took a 36-hour Greyhound bus ride to New York City. So instead of getting on a plane, which he usually did, he basically took a very circuitous route because he thought he was about to be arrested. On December 11, 2000, in the middle of all this, Durst decides to marry his longtime girlfriend, Debbie Sheridan. The wedding was officiated by a rabbi they picked out of the phone book. The only people present were Durst, Sheridan, the rabbi, and 2 witnesses who were chosen by the rabbi that they did not know. They were married in an office building. They did not spend their wedding night together, and Durst would explain the marriage, as had been quoted in the New York Post, as a marriage of convenience.
Why was Susan Berman killed? Prosecutor Lewin explained the logic of the state's theory about the motive.
Susan Berman was of extreme interest to the detectives, but they were waiting to contact her very near the end because of the closeness of the relationship. They never made contact with Susan Berman prior to her murder. They never contacted her. They were planning on it, but no contact was made. However, despite having never been contacted by investigators, Susan lied to Bob Durst and told him that she had been contacted and planned to speak with the investigators. Now, how do we know this? We know this directly from Bob Durst.
Susie Berman said the police are contacting, Los Angeles police are contacting me. They want to talk to me about Kathy Durst's disappearance. And this was probably before the PR guy told me that the newspapers are doing these articles.
Prosecutor John Lewin told the jury that he decided not to re-exhume Susan Berman's body in an attempt to locate DNA evidence because he thought any DNA would have been too degraded to test.
George Shamlian was assigned as the lead investigator on the case. Now, in January 2013, my office began assisting Detective Shamlian on the case. I have a specialty in these areas. This is what I do. Detective Shamlian calls me, and he's going to tell you they originally contacted me because he had gotten a request from the FBI to exhume Susan's body. So I was brought in. I was asked about it. Detective Shamlian's going to tell you that I advised that given she was shot from behind execution style, that it's no struggle, you're not going to get any DNA. It's not a route you should pursue, because if you get anything, it's likely going to be contamination from over the years and not something from the crime.
We were not allowed to record a defense objection to what Prosecutor Lewin just said because the objection came outside the jury's presence. Under California Professional Conduct Rule 3.7, a lawyer is not allowed to try a case in which he is likely to be a witness, and that's basically what the defense accused Lewin of doing, making himself a witness there. Lewin said a detective could testify about this issue with exhuming the body, even though he himself made the decision not to dig up the body. Defense attorney Dick DeGuerin moved for a mistrial, but the trial judge denied it and said testimony from a detective on the decision not to exhume Berman would suffice. Texas Judge Susan CRISS presided over Durst's Galveston trial, where 3 of Durst's current defense attorneys also represented him. Judge CRISS told Law and Crime earlier today she was not surprised by the defense motion for a mistrial.
Oh, absolutely not. You'll see that many, many times. They are very good attorneys. I have a great deal of respect for them, and they will do everything that they possibly can to make sure there's not a conviction in this case. I think a lot of the things that Robert Durst did were connected to the disappearance of his first wife. What happened with Susan, what happened with Morris Black, it's all connected. And to tell the story in a way that makes sense, I think you have to do that. I think he's got the right strategy on this. But I don't think John Lewin's going to leave anything on the table. He's going to use everything he has, and he's going to put it all out there this time. It never ends, and I guess hopefully it won't end until justice is achieved. There's been so many things that have happened. Everything in this case is different. I mean, this is just the most unusual situation ever.
Our panel is back to talk about this case. So, Mike Korobenik, you're about ready to climb out of your chair with an objection there. Explain.
When a prosecutor is given an opening statement, he's not sworn in, he can't give evidence, and he can't speak as an expert witness as to why things weren't done. I think this is going to be an interesting ruling. I don't think it's over yet. I think it's going to rear its ugly head again, and I think the defense will prevail when it's put into context.
Michael Bryant, 2 days of opening statements from the prosecution, and we were expecting things to wrap up yesterday. They're going to spill into Monday. How long is the prosecution going to give an opening statement?
Oh, that was the opening? I thought I was watching the closing arguments.
Almost.
That's my mistake. Yeah, I mean, they're giving a 5-month estimate. Is that just for the openings, or is that for the whole trial? It's really an interesting risk being taken by Prosecutor Lewin here. Is it too much for this jury? Is it too much razzle-dazzle entertainment or not? Ultimately, they'll decide, but it is unusual.
I mean, David Ring, he basically produced a TV show here for the jury to watch on opening statements. They might as well just watch the debrief. This is actually less complicated than these opening statements.
You look, I mean, it's 30-year factual history that ties everything together in this case, so I get it. But I also think this prosecutor has to be very careful. I think he's trying to turn himself into a star using this case as the vehicle to do it, and it could be a real turnoff at the end of the day.
I think that is the criticism that many people are thinking right now. We've got to try a case, and in many states, there's time limits on openings and closings. For instance, like the state of Georgia. This is not one of them. Again, we're going to be back in this case when things pick up on Monday. And still ahead tonight here on The Debrief, the trial of an Iowa mother. Authorities say strangled her own daughter to death because the daughter reminded the mother of her ex. Day 3 of testimony is straight ahead. Day 3 of testimony now in the case of an Iowa mother accused of strangling her 5-year-old daughter to death with a pair of pajamas. Prosecutors say the defendant confessed. The defense says the confession was coerced. Firefighters found Chloe Thomas dead in her bedroom on July 19, 2018. Her mother, Kelsey Thomas, told detectives she put Chloe down for a nap around 1:30 and then settled down herself for a nap. When Kelsey woke up, she says she found Chloe dead in the closet and called 911. The defendant initially denied harming her child when detectives spoke to her the day after her daughter's death.
All right, and I'm going to rule this out. I did not kill her, okay? That is the truth. All right, no, she was not asleep when I left the house this morning. She was awake. All right, I didn't want to take her with me. She's been acting out. She's been doing this for quite some time now, and I don't know why. I don't know why she's been acting out. Okay, there was never any physical abuse or any reason to, I don't know, I guess spanking. That's it. I've never hit my daughter. I've never choked my daughter. Nothing.
The investigator who led that interrogation says he was trying to figure out the level of stress in Thomas's household and told the defendant she was free to leave at any time.
I don't recall if she did. I know I think at one point maybe she said she was done in one of the interviews, and I recall, pointing at the door and saying, "There's a door. If you want to leave, leave."
At least for July 24th, did she ever leave?
No.
Well, did she ever leave prior to the end of the interview?
No, she didn't leave unannounced. She stayed in till the end of the interview.
Was she handcuffed at any time during July 24th?
No.
How did she leave on that day?
She walked out of the police department, and I assume she drove home.
The defendant's story started changing the next day when she was brought in for questioning again.
When I laid her on her bed is when and it wasn't actually vomit, it was just there.
So we talked to the firefighters, they suctioned her out. They said she had a large amount of stuff coming out. Which again, if someone's deceased, why would things...
I don't know. I had found that on her mouth. So I sat her up and I used my finger to try to get out what was ever in her throat or what I thought, was in her throat. And then I laid her back down and I called 911.
The defendant went on to explain how she picked up her daughter when she says Chloe began to twist.
She had jumped in her bed, and then as I was coming, I came into her room, and she had jumped out of her bed, and I tried to grab her arm, and she slipped out of my arm, and I went right out of her bedroom. I grabbed the pants, and I just went like this, and I pulled.
Where was she at?
She was in the room. She was, like I said, I tried to grab her arm, which stopped her, and she turned, got my arm out, or got her arm out of my hand. So I grabbed the pants, and I threw them over her, and then when I pulled, I don't know, honestly, if I twisted, or, I know she had turned around. Because when I first, and we started to fall backwards. So I picked her up, and I laid her on her bed, and I held her down, and I told her, I was like, you need to go to sleep.
You were still kind of angry at that time? Buster said in bed, how did you do that?
After I laid her on, I picked her up, and
The medical examiner ruled Chloe's manner of death as a homicide, but the defense won a motion to prevent that testimony in court. The medical examiner did testify how she ruled Chloe's cause of death as strangulation.
There was injury of the carotid arteries just above where the clavicles are. So it's lower than I would expect with a typical suspension. It's on both sides of the neck, and it's more common with strangulation, a manual strangulation type of injury. There was, in fact, a struggle. Chloe had been moving, her mom had been moving, and the pants, which were essentially the ligature, would have been in a position to shift on her neck as the bodies shifted in their movement. Chloe turned, which would account for some of that injury in the back of her neck as well as the front.
On cross-examination, the defense wanted to know whether the medical examiner relied on the defendant's alleged confession to reach some of those conclusions.
I think that the story is completely consistent with the sequence of events that are described with an asphyxial death, such as strangulation or suspension. It was more my autopsy findings, the irregular ligature furrow that was upwardly canted but associated with internal injuries, including the petechiae of the larynx, the vocalis muscle hemorrhage, the asphyxial evidence of neuropathology that was more in keeping with the second story than the first story, which would have been a sling-like apparatus.
Our guests are with us one final time tonight. So David Ring joining us on the West Coast right now. How does this add up to you? Because one way the jury might look at it is we've got three relatives saying the defendant's behavior was very, very strange when the daughter died. And then you've got the defendant changing her story. That could add up to a conviction.
It could definitely add up to a conviction. Now, look, juries are reluctant to convict mothers who have other children. This lady has another child, but we need to hear more evidence so far. It's a convoluted story.
Yeah, I mean, we've also seen other convictions of other parents, though, including in the state of Iowa. So, Mike Korobanik's strangulation here or some sort of accidental hanging type injury?
Well, I thought it was interesting the way they ruled that she couldn't rule it a homicide, but it sounded like when the expert was testifying, that's exactly what she did, was rule it a homicide and corroborate it with the confession.
Yeah, I mean, basically, we saw evidence start to toe up to the line of homicide. It seems like the defense just didn't want that word to come out of the expert's mouth.
I agree with you there, but it did, and I think it's going to be a very big play for the prosecution when they have the expert and then the confession. It's not going to look so coerced.
Michael Bryant, what's your view of the evidence here?
Well, I think there's enough to get the jury where they need to go because they don't have alternatives at this point. Who else but the mom was in the house? That seems to be undisputed. There's also the background story that she liked the new 2-year-old better with the new boy, the new husband, and Chloe was kind of old news. And so I think those things start to build on the actual facts, which are a bizarre story that the kid was hung by the pajamas in the hanger. That story itself is just too odd. It just doesn't explain away the physical evidence. It makes no sense.
I mean, David Ring, is it enough for the prosecution to basically paint this defendant as a monster, that she was so interested in the new child because the old child looked like her ex?
I don't think that's going to be enough. I think they need more. Our juries want to see some real forensic evidence, and they might get it, but just the story alone is not going to be enough to convict.
Michael Bryant, go back to you on this one. So what else should the jury get here, or does the state just not have enough and therefore we're talking acquittal?
I think they're relying so much on the confession because they don't have the other stuff, and they're hoping the whole package sells this jury.
And it might come down to expert testimony trying to explain away that confession. That gets really tough for the defense, though. Hey, look, we're out of time for this week. We'll see you back here on Monday, right here on the Debrief.